Disputes has become my life. And I live and breathe disputes, and I know I've seen the participants list for this event. I know that many of you do that here as well, and at least our 4 speakers. It should be a part of the job description when you get a job at the SSC that you will, as part of your job, is to really live and breathe disputes, because you live in it all the time, and it's wonderful. I can't stop talking about that, how wonderful it is to be there to help companies to really resolve disputes in a best possible way. At the SSC, we solve around 175 disputes per year. The majority of them are international, and that's why we have invited to this event. International disputes is very much at the heart of Stockholm and at the heart of the SSC Arbitration Institute. We see parties from Norway, Denmark, Germany and Lithuania each year here in Stockholm. And we almost always see them using the SSC arbitration rules. Not the expedited arbitration rules, not mediations, and not SSC Express, but the flagship, the arbitration, the flagship rules. And we would like to change that. We would like to get more companies, more law firms to promote other ways of resolving disputes. Norway, Germany, and Denmark are 3 of the 4 countries that Sweden trades with the most. 3rd place is for the USA, but we didn't invite them today. We invited Lithuania instead, and the Baltic countries have a very strong connection to the Nordics, and we see significant trade between the Baltics and the Nordics. And that really brings us to today's topic, and it's about contract negotiations and especially negotiating dispute resolution clauses. And we know at the SSC that there are quite some differences between our 5 countries, but there are also some similarities. So we are going to deep dive into this in 1 hour today. I will not do this on my own. I have a very good panel of speakers. They are all part of SSC's board, the SSC board. And we have Knut Jakob Knudsen, from partner at Simonsen Vogt Vig in Norway. We have Henriette Gerna, partner at Gorrisen Federspiel in Denmark. Sven Lange, partner at Busse Disputes in Germany, and Ramonas Odzievicius, was that correct? Yes! Partner at Motieka in Lithuania. So please join me on the stage. It's free seating up here. Great. So our plan is to start with a short overview from each of your jurisdictions, just to get a quick look and feel of each country. Can I start with you, Knut? Norway. What's it like in Norway?
Okay. First of all, thank you for the invitation to sit on the panel, and I think it's really great to share this the stage with these very accomplished colleagues to my left. Just to give you a brief, I guess, introduction or taste of what dispute resolution is like in Norway. Some of this you may know, some of this may be new to you. First of all, I think most commercial disputes are resolved by the state courts. We only have general courts, so there are no special courts dealing with specific types of cases. It's one court system with general courts that deal with virtually everything. And there's several reasons why the courts deal with most cases. I think one is that the public has a great deal of trust in Norwegian courts. I think that Transparency International had a poll in 2022 which indicated that 92% of the Norwegian public had a very high level of faith in their courts, which was much higher than the EU average, which I think was about 63%. In addition to that, the courts deal with cases very, very quickly. The average for the Oslo District Court, which is the biggest court in the country, is approximately 5 months. And the courts of appeal across the country also have an average of dealing with cases within 5 months. So things go fairly quickly. So that also, I guess, adds to the popularity. Arbitration is not as common as it, for instance, is in Sweden. But this differs a little bit from business area to business area. So, for instance, with regard to shipping and offshore, arbitration is much more common because it's normally more international contracts and international parties in those types of disputes. Another couple of things I thought I'd mention is you mentioned, Carolina, during your introduction about mediation. And mediation is becoming, or has for a while been very, very popular in Norway. It's sort of like an integral part of the Norwegian court or the system or the procedural orders, so that 25% of all cases, the courts conduct mediation. And they reach settlement at 75% of those cases. So it's sort of a natural part of having a court proceeding also involves mediation. Now, with regard to just briefly touch upon arbitration, Norway does not have a strong institution like the SCC. So we have, for a number of years, had ad hoc arbitration. It has long traditions. We can go on talking about the reasons for this, but I think that one is lack of institution, and the second is that Norway has quite a transparent legal market, legal system. Everybody sort of knows who everybody else is. So at least for domestic disputes, ad hoc arbitration works really well. That being said, I think that there are lawyers, or an increasing number of lawyers, who now feel that, that there is a lack of predictability with regard to ad hoc arbitration. So particularly for international disputes, but perhaps disputes in general, we should be looking to have more institutionalized arbitration. And one of the steps in that direction is the NOMA rules. I don't know if you've heard of this, but the maritime the maritime law associations in the Nordic countries established NOMA, which is not a Copenhagen restaurant in this context, which is a semi-institutional arbitration. So it's a set of rules, including fast track rules, including rules on taking of evidence, which gives predictability to the process, but it's semi-institutional because there is a procedural committee which is available and can step in if there's a need for it, but normally they don't involve themselves in the case. So it's only if there are challenges to arbitrators, for instance, or there is a dispute about the arbitrator's fee, then the procedural committee will step in. But if not, then the parties are handled in the case as sort of an ad hoc arbitration, but within the rules that are specified. Yeah.
Very interesting. That's something you don't see in that many countries, this setup.
Yeah.
Can we continue to Denmark?
Absolutely.
Henriette?
Absolutely happy to say a bit about the Danish dispute market. I think, first of all, maybe the first point is that within the last 20 years, I think cases have become more complex, bigger cases. So we've certainly seen a rise in disputes, both court and arbitration. Smaller cases still get settled. It's the wise thing to do. Can also be the wise thing to do for the bigger cases, and certainly the aim for everyone, I think. But definitely a rise, definitely an internationalization of disputes, both arbitrations, but actually also court cases, bigger teams, more thorough investigations into documents and all of that. In terms of preferred dispute resolution method, I think for commercial disputes, it's fair to say that arbitration is predominant. Most contracts will include an arbitration clause. I think there was perhaps 10 years ago or 20 years ago sort of a thought that home turf advantage could prevail. So if you were a Danish company and you can get your foreign contract party to go to the Danish court, then that would be great and you would have an advantage. I don't think that's the case anymore. And one of the reasons is probably that our court system is struggling somewhat. So commercial cases are not well placed in the Danish courts from my perspective. Obviously, cases do go to the courts, but they're primarily cases outside of contract, so liability cases, D&O, insurance, what have you. But the commercial cases that arise out of contracts will go to arbitration. And even if arbitration hasn't been agreed, I think most counsel would have a look at it once the case arises, because it's by far the quicker solution. And also, there are areas where the court simply, they're generalists as well. So there are areas where they don't have the knowledge and skills that businesses are looking for in the people who are going to determine their disputes. So for instance, post-M&A disputes, very few judges have seen an M&A contract, very few know about the whole system. So also for that reason, I think arbitration is preferred. There is great trust in the courts, but there isn't trust in the way the courts handle the cases. So what that means is we actually see quite a number of judges acting as arbitrators in the Danish market. Supreme Court judges have always been called on for very difficult cases involving Danish law issues. That remains the case, but there are limitations to how many cases they can take. But then once they retire, they become regularly, a lot of them become very prominent arbitrators. Professors also play a role in the arbitration market, obviously practicing lawyers. And there are a few, quite a limited number of individuals who have sort of left the counsel work and now do exclusive arbitration work. So I think it's a very international arbitration community in that sense. I think businesses are looking to have their disputes solved by arbitration. They're looking to the Danish Institute of Arbitration, which is good for many cases, but I think for a lot of international contracts, clients will look elsewhere. They will look to the SCC, LCA, ICC has always been big in the minds of Danish businesses as well, and obviously depending on the markets elsewhere.
Let's go to Germany.
Thank you very much.
Stop.
Thank you, and thanks also for the invite, of course. I think the key thing in Germany, but maybe also in other places, is that most disputes are probably settled even before they get to the really serious stage. And I think in many cases, there's negotiations on the business level, on the CEO level. Sometimes that's also prescribed by dispute resolution clauses. And in I think most cases, I as a disputes lawyer don't see quickly at the beginning, and then it goes away. What is much less common is like a type of formal mediation, I think. In Germany, there has been lots of talk about mediation and how it could be a way forward, but generally it's just, business-to-business talk, CEO talk, and this formal mediation process isn't terribly popular. Now, assuming we can't find a settlement, then the standard way of resolving disputes in Germany is to go to the courts. And perhaps somewhat similar to Norway, there is trust in the courts. The courts are generally perceived as being quick. I think not quite as quick as the numbers Knut mentioned, but still, I think a first instance decision you normally get in under a year, and second instance also shouldn't take terribly long. So there's generally trust there. So if you're in a purely domestic context in Germany, most disputes will go to courts, except post-M&A disputes. And that is really a big exception, that M&A disputes are predominantly sent to arbitration. There's arbitration clauses in the contract, even if it's purely domestic. I once had a conversation with an M&A lawyer who said to me, I don't know whether the clauses I draft actually work the way I envisage them, because there's no case law really telling him whether that's the case. And there's actually been some concern about this lack of precedent, and now there's a reform to create commercial courts, which are supposed to be more specialized, and particularly specialized on these kinds of disputes, to bring them back into courts to some extent, at least, to have precedent. But that is ongoing, and whether that will actually work is up in the air at this point. So what is typically arbitration? It's, as I said, post-M&A disputes, and it's disputes that have a connection to, have an international element. Once it gets international, concerns of enforcement or these things lead to a selection of arbitration as the preferred method. Another method I just want to briefly mention that is popular is also in some instances expert determination, which is more for technical issues. So, for example, if in a post-M&A contract you need to analyze the accounts of a firm to determine the purchase price or these kinds of things, there it's not a full-blown arbitration, but it's rather a selection of an expert who determines what the owed amount is, and that you find a lot in these kinds of contracts, can cause all sorts of difficult problems. How that relates then to the arbitration clause that will also be in the contract, but that nonetheless you see it a lot, and that is also pursued. I think that's the main things. As I said, mediation has been a lot of talk about it, but you're not really seeing it. I think that's maybe the main things for a start to say about the dispute resolution landscape in Germany.
Thank you. And finally, Lithuania.
Thank you. Lithuania is probably the youngest country in terms of business history. We are having only 30 years of business history in Lithuania, so it's quite young, but well developed in arbitration. We are model law country, first of all. Very arbitration-friendly courts, starting from district court that assist arbitrations, and Court of Appeals and the Supreme Court, of course. And very strong arbitration community, by the way. And back in the 90s, there was a privatization procedure where arbitration clauses was a part of new contracts. It was new to the market. And the market has been dominant by litigation. Commercial disputes went to courts. New generation arose, and more and more arbitration clauses were agreed between the commercial parties, especially in international contracts. Our local community started understanding that expertise, industry knowledge, ability to appoint arbitrator is an advantage. And we started negotiating arbitration clauses as well. We have local institute, Vilnius Court of Commercial Arbitration, that is successful. It has a flow of, let's say, 30 to 40 cases a year, mainly regionally domestic or regionally international, not that big as cases in the other institutes. However, trust in arbitration still growing. There's a place to grow because litigation is dominant for commercial disputes, especially for local ones. And our courts, the same, we have only general jurisdiction, we do not have commercial courts. Courts are quite effective in terms of timing. So we have less than 12 months for first instance, around 6 months, maybe 8 months for Court of Appeal. And if cassation is admitted to the Supreme Court, additional, say, 6 to 8 months, depending on a case flow. However, general courts are general courts, very busy, and sometimes lack of industry knowledge. That is important for businesses. And maybe very special expertise, like you said, post-M&A stuff. It is important for parties to go to arbitration. What else? If we speak about industries, the most important industries in Lithuania are agriculture, production, food processing, logistics, and biotech. And however, if we go to the disputes, the main and most important industry in Lithuania is energy. It generates amazing amount of disputes, both litigation and arbitration. And I would go number 2 currently, possible pending cases, food industry and fertilizers. Number 3, my guess would be construction. And the number 4 is commodity trading. We have strong traders, strong commodity traders in Lithuania. And then, however, if we speak about trading, commodity trading and arbitration, probably it is Fosfagafta, like grain traders, oil traders. We choose to have niche arbitrations instead of having Vilnius Court of Commercial Arbitration or, for example, SCC Institute.
Thank you. And to give a bit of a Swedish perspective on it, I think most of you in here already know that, but arbitration is preferred in B2B business in Sweden, I would say quite clearly so. The SSC is the largest institute. That's why you are here. And we have seen, we have very good trust in the Swedish courts, but as in Denmark, it takes longer and longer time, and we don't see any 5 months before we get the first ruling, to first ruling. That's really amazing in Norway. It takes much longer, and especially if you go to the Court of Appeal as well. But we have also a very strong and long history of going to arbitration with commercial disputes in the Swedish markets. As SSC has had this strong position in Sweden for a long time, the Swedish companies have usually no fallback option. I know that most companies prefer the SSC strongly because that's the home, where you feel at home. But if we go into what in your markets, where do you see, if you can't get the home jurisdiction, where do you end up? I know that you've already touched a bit on that, but I know that you started as to say that ICC has a very strong position, yes, for example, in Denmark.
That's right. But I think that's the institution. The forum is really up for negotiation, and I think, in my experience, it depends tremendously on the parties, and I think I accept that many are quite professional about negotiating the dispute resolution clause, and certainly our transaction lawyers often involve us, but nonetheless, the seat is something that the parties need to find somewhere that they feel isn't the other party's advantage. So they go for something neutral. And what is neutral depends really on the parties. So, but ICC is certainly dominant in Denmark. SCC, I think Danes feel very comfortable with the idea that things are being run out of Sweden, even if the seat might be elsewhere in Germany or wherever. LCIA. And obviously, if you're on the Asian market, you have to be open to other institutions. I think most would like to stay clear of the US. But obviously it happens that you have to agree to the US as well.
Yeah, I think, obviously there are some German companies who are quite large and who try to really do everything to use that power that comes with it to get to Germany in one way or another. If it's not possible, the preferred choice in my experience is Switzerland, because the language is the same. court, like you can communicate with your attorney in German in normally. That's a huge advantage. You can read the precedent in German, most of it. And the law itself, the Swiss law, is also very close to German law as such. So for that reason, I think Switzerland is preferred if it can't be Germany. And then it would largely be ICC as well for the international cases. Might also be the Swiss Institute in some cases, but I think that's much less common. If we are talking about disputes that go to Eastern Europe, I think the VIAG in Austria has a good position, and I also think the SSC has some cases of that type. And yeah, as Henriette says, I think if we're talking about Asia, then it would go to Singapore probably. Yeah.
Is that the same for Lithuania?
No.
No.
In Lithuania, I can declare SCC is the champion. Brand awareness in Lithuania is very high of SCC. Brand equity is very strong. Trust in Stockholm as the seat is perfect. So I wouldn't say there is a competitor to SCC in the Baltics, throughout the Baltics and especially Lithuania. However, of course, ICC, LCA, they do have some presence for sure. VIAG is also a choice. Asian institutes are not popular at all. As I've already mentioned, GAFTA, FOSFA, is doable as well. But SCC, you can see from the caseload, is a champion.
Yes, we see that. Can you just give a word also about Latvia? Because that is a quite strange situation with institutions in Latvia.
Yeah, there is one strange question. There are too many institutes.
Yes.
There were too many institutes, and the number is decreasing, of course, but there are still, for this very small market, is too big, the number of institutes. But I believe the development is progressing. Of course, we have some issues with annulment procedure. Let's leave it for Latvians to discuss that exact issue. That's interesting because the three Baltic nations are different in arbitration. I mean, the progress of arbitration, acceptability of arbitration, and the number of institutes in Latvia, we decreased trust in this exact measure of a dispute resolution, and we are gaining now. We're gaining. The trust is high in Estonia, I believe, and the same is in Lithuania.
Great, thank you. And finally, Norway.
Norway, yeah. I think the situation in Norway is a little bit different from everybody here. Norway is historically very strong within shipping, has been for well over 100 years. And with regard to shipping disputes, London is the go-to place. Mainly because the standard contracts that are used often refer to the LMAA as the preferred place of arbitration and the preferred set of rules. That being said, I think that there's a number of Norwegian lawyers who feel that it's a disadvantage or they don't like the fact that all the cases go to London because it just provides work for British lawyers who are terribly expensive, and sometimes you need a double set of lawyers there in addition to the Norwegian lawyers, so the whole case becomes very expensive. And that's, I think, one of the reasons for the establishment of NUMA, because you wanted to sort of take some of the cases back from the British market. Yeah. If we disregard shipping, I think that there is really no institution that stands out particularly. I see lots of very big variation, essentially. There is, I think that in many cases, it's simply the bargaining power of the parties involved and which nationality they have. So, for instance, if it's a strong Swiss party, which there was a case I was involved in last week, very strong Swiss party, they suggested the OSA in Switzerland and arbitration there as the and Swiss law. But I mean, the SEC is very well recognized. I had a case between a Norwegian party and a Chinese party where we recommended and the parties accepted the SEC as the preferred institution, and that was acceptable to both parties because of the history and the excellent reputation the SEC has, and I guess Sweden's position as a neutral state. Yeah. But apart from that, it varies quite a bit. So I wouldn't say that there's any particular institution that stands out apart from the shipping.
No. And you were already into that question a bit. What would you say in your respective markets, if it differs, are the main factors when considering different dispute resolution methods? When you're in this negotiation of dispute resolution clauses, what's most important to Norwegian companies, if we start there?
Yeah. I was thinking about this, and I mean, you have the various factors that I guess that all parties consider. It's like speed, like how fast can you have a decision? What's the expertise or perceived expertise of the people deciding the case? Should we go to the courts? Are they good enough? Do they know this area well enough? This M&A transaction, what it may be. But and the other factors that I guess are familiar to everybody. But I think, from my personal view, this is decided to a very large extent upon familiarity. So if Norwegian lawyers are very familiar with the courts and not so familiar with arbitration or perhaps an institution in another country, then many cases they'll settle for what they know. And then that combined with bargaining power is often the determining factor in my view.
I agree. Anything?
I believe in Lithuania, if we go to the business level and decision makers there, confidentiality is number one issue in Lithuania. When we ask professionals why arbitration, again, it is neutrality and expertise and possibility to appoint your arbitrator. One of 3 or one of 5 sometimes.
Yeah. Different in Germany?
No, I think that's all very familiar. I think maybe one thing to stress is also bringing me back to larger German companies, the attempt to get a home advantage or at least avoid the perceived home advantage of the other side. Definitely, I think a German company would always try in an international contract, try to put in a German seat, probably also the DIS, the German Institute, and then would perhaps slowly move to somewhere else, but not too far away. So yes, it is home advantage, considerations, it is familiarity, and the other thing then, if it's about should we go to courts or arbitration, a huge factor in favor of arbitration may be expertise and the fact that you can select an arbitrator who has actually experience in the area. So that I think are the main driving factors.
But not confidentiality.
I would say many people will list that as well, and the German Institute has a rule expressly saying that cases there are confidential. So it is a consideration as well. But also the cases in German courts aren't that incredibly public either. So you can go to the hearing, but it's not like you can read all submissions freely and very, very simply. So it is a consideration, but maybe not the most important one.
That's a big difference to the Swedish court system, where everything's very public. Henriette, for Denmark. Then.
No, I think everything has been said pretty much.
Yeah.
But time is an issue. How quickly can we get a resolution by competent arbitrators? So in choice of arbitration institution, I think it's also quite important, at least when seeking advice, whether that institution is in a position to appoint the right chair, because that has such a great bearing on the proceedings. In terms of, just to add what was said, I think most Danish business people will feel most comfortable with Scandinavian law, either country really, or common law. So actually more so than to choose German law, because I think most Danish lawyers know a bit more about common law and international trade than they do about Central European legal systems and civil law systems. And then the last point about confidentiality, just to address that, I think many perceive arbitration as confidential. I don't think it necessarily is in Denmark under Danish law. Certainly the proceedings are closed, you can't invite people in, but a party is free to talk about an arbitration unless parties have agreed to confidentiality. So that's an issue when you draft your clause.
And how is the confidentiality in courts in Denmark?
I think it is a bit like the German courts. You will not have access to written submissions. But once the hearing is on, it's open to the public and documents are read out. And the judgments will set out many of the key documents verbatim. So if you want to keep things confidential, it's not the right place to be in. In terms of sharing information about your business, I think most people feel more comfortable about having that as part of the arbitration case.
This is really interesting because it's so different to the Swedish way of working in courts. Sorry. If we go into other types of dispute resolution methods, we touched upon mediation, settlement, the discussions in other forms, expert determinations, which we also do here at the SSC. How does that work? Do you want to start? Norway again. Do you?
Yeah.
Yeah. No. Continue. I know that you use quite a lot of mediations successfully.
Yes. So like I said, mediation is an integral part, I would say, of the Norwegian court proceedings. So as a standard point on the agenda for the first case management conference that you as a lawyer will have with the judge involved is the question of mediation. And the judge will weigh sometimes quite heavily in recommending mediation. I think that the courts are becoming very, very enthusiastic about mediation because they see that they have a very, very high success rate. So they want to do more of this. And one interesting thing I just have to say is that the court or the judge can decide to conduct mediation even if one or both, in fact, both of the parties are opposed to mediation. But it used to be that if one of the parties was opposed to mediation, then it could only be resolved or decided if there were special circumstances. The legislation was amended last year, so there's no requirement for special circumstances. Because the courts have experienced that even though the parties are maybe initially reluctant to enter into mediation, they still manage to find a solution. So for that reason, this is becoming more and more popular. And one other thing I thought I would just mention is that when it comes to arbitration, it doesn't seem to me that mediation is it isn't such an integral part of arbitration as it is for the court proceedings. So from the normal arbitration clauses that I see, it's a straightforward clause with no initial mediation. There are there are two-step clauses on occasion, but it's not the normal one that I see. But I know that also within arbitration, parties are perhaps looking more and more to solve their disputes through mediation. So again, to mention NUMA, they adopted new mediation rules last year, and with a new arbitration clause available where mediation is part of the process. Yeah. So maybe we'll see a similar development there.
And this is a trend in the market, I would say, that many arbitral institutions, we have, of course, model clauses, dispute resolution clauses on our websites. They are quite similar to each other, I must admit. but we have several different versions where you can include mediation or other types of quicker ways of resolving a dispute.
In Lithuania.
Jonas.
Yes, I would say we are still dominant by litigation and arbitration. However, mediation is gaining its stake in the dispute resolution ecosystem in Lithuania, and thanks to judges who are successful mediators in commercial disputes, and commercial people started understanding that it is the way of solving dispute. However, if we go to negotiation. So I believe that at the current stage of development in Lithuania puts a lot of stress and effort onto negotiation part before concluding the contract, but not when the dispute arose. So the dispute negotiation is still a product to be developed in my country.
You're on your way.
Yes.
And Sven.
Yes, before I go to Germany, maybe just one sentence about Norway, because I was actually involved in a Norwegian court mediation 2-3 years back with a colleague of Knud's. And I thought it was an amazing experience. That we had 3 judges who really knew what they were doing and who clearly had a mediation education, so to say, and it ended successfully. And I thought that was really impressive, just as an aside. In Germany, as I said, mediation isn't big. It's growing maybe, but it's still small, I would say. That might have to do with the fact that courts have another way of achieving settlements, and that is maybe a bit of a peculiarity we can talk about a bit more later. German courts at the hearing, they quite openly will tell both parties why their case is bad, and kind of create a bit of fear in them that, you know, if this comes to a decision, it might go against them, and that. I wouldn't call that mediation. I think it's a bit of a different kind of animal.
It's
but
a warning.
Yeah. But it does have an effect, and it is effective as something promoting settlement. Whether it's always a good settlement is a different question. And I think because of that, mediation maybe hasn't made gains that much yet.
Mediation was sort of incredibly big 15 years ago, at least in theory, in Denmark. And there were mediator training of lawyers, same as arbitrators training, and the courts initiated mediation programs. And I think it's still around. I think for smaller matters in the court, it's incredibly effective. For commercial matters in the court, it doesn't exist. It's voluntary, and I think it's incredibly rare that parties actually take that kind of offer from the courts, because if they're in court, they feel that it's because they have a dispute. The type of mediation is, I think, what is called facilitatory. So it's about testing parties' views and how do you feel about your evidence and your legal position, but not stating a position which will sort of steer a party in a certain direction. In arbitration disputes or any commercial dispute, I think it's part of the toolbox. I think you have to take it to the parties whether they want at some stage to go to mediation or to have regular settlement or expert determination. Personally, I'm somewhat reluctant to put it into the contract, because I think it is so important that it happens at the right time. But it's certainly part of our practice. I think most of our big arbitrations have had a short period where we attempted mediation, not always successfully, but always helpful, I would say. So I think it's part of the toolbox. It's popular, but if I look at, say, the Danish Institute and their statistics, I think they've appointed a mediator 4 times or 5 times last year. So it's not big. I think it's more of a initiative taken by parties' counsel. And for complex disputes, we would seek out individuals that we feel very comfortable with. And quite often we actually go to London for mediation.
It is well used in London and in common law countries, but also in Norway, and much more so in Denmark actually than in Sweden. And it's quite similar in Sweden. It was very popular 15 years ago. Everyone talked about it. Not that many tried it, but we have seen an increased interest the last year, and I believe that it could be very well used for complex commercial disputes in Sweden as well, as we see in England and Norway. But it's something different from just negotiating between the council, I would say.
Could I just add a couple
Yes,
points on mediation
please.
on that? And just to clarify a few things. First of all, the person who, if there's a mediation, the person who is a mediator does not later participate. If the parties don't reach an agreement, that person does not continue as a judge in the case. So these are separate procedures. The second thing is that Norway, I think, largely has a success when it comes to mediation within the court system. As in Denmark, and I understand the cases in Sweden and other places as well, there is a very large pool of Norwegian lawyers who have attended mediation training and who have since then not really had any assignments as a mediator. So it's really within the courts who have been the most successful. And then the final thing I just wanted to add, it was that if you are counsel and you say yes to mediation, I always tell my clients that there is a certain pressure that you will be exposed to when you are in a mediation, and that the mediator is obviously very interested in getting the parties to settle, and that the pressure that is exposed or is put to one of the parties does not necessarily correspond to the strength of their case. So sometimes I feel that a solution is reached maybe largely because one party is more flexible than the other, despite perhaps having on the merits a much stronger case. So I don't always recommend mediation if I feel that the client has a very strong case. Yeah. So there are drawbacks to mediation, I feel.
It's an interesting point. If we speak about mediation in Lithuania, the cultural stuff, mediator has to be big authority for the parties and councils. Therefore, at the current stage of development, only judges are super successful as mediators.
So you don't see arbitrators as mediators?
Too early, I believe.
Too early, and you don't have mediators?
Probably we have private mediators and former judges, but the strength of authority, the possibility to influence, to convince you, to open up with your weaker points, or at least listen to, it is important for us.
Yes. Maybe a final question. Any great advice? Because there are a lot of people in this audience negotiating contracts, negotiating clauses. What would you say? What's the advice to them in relation, if they are, let's say they are Swedish lawyers in a business negotiation with a Norwegian company? What would you recommend? What to avoid, where to go, and so on? Anything that hasn't already come up?
I wasn't quite 100% sure of the question, but one piece of advice that I have is use the standard clauses that are available on the institution's websites. Almost all institutions, I don't know in the world, but at least in Europe, have standard clauses. And if you apply those without making changes, then you're good. You're on the safe side. Because I have seen some I guess we call them homemade clauses, and that may be offensive to the very professional lawyers who have drafted these, but they're not always as good as they should be. I came across one a few weeks ago where the clause said that the parties had agreed to arbitration, but at the same time the clause also said that each party can have or ask for the case to be dealt with in the courts. And then, of course, the question arose because of what happened was one party initiated arbitration, and then the other one said, no, but we understand that you want arbitration, but we want have the courts resolve the case. So we referred to the clause and said, we have this a veto. But the question was, of course, is this a veto or is this just an opportunity that each party has, but it only applies to the person or the company initiating the process? So it's in a dispute in itself. So yes, that's my advice. Use the available
It
clauses.
sounds expensive.
Yes, it's not a very good starting point because normally there's the dispute on the merits is enough in itself. So if you have a dispute with regard to procedural issues starting off, then you're looking at a nightmare. Yeah.
I agree. Please use our standard clauses. For if you are in a negotiation with a Lithuanian or a Baltic company, any good advice? What to think about that?
It depends on bargaining power, right? We're small economies. For example, Lithuanian GDP is 78 billion USD. So it's not a big number. However, we have strong companies and strong negotiators. On the other hand, I would go Knut's way by saying, look, it's easier to negotiate with Lithuanians by saying, look, take a standard clause from a reputable institute, set the reputable seat, and that's it. Otherwise, it's drafted arbitration clause with pathological stuff inside. Yeah. So if we speak about Lithuanians, SEC clause, standard one, Sweden as a place, and you go.
Can never go wrong. And for a German company.
Yes, so if you're negotiating with a German company and they suggest the application of German law or German courts or German seat of arbitration, I think there's a couple of things you need to be aware of that are culturally a bit different and that if you don't think about it, you wouldn't expect it. So assuming you go to a German court and the proceedings run and then there's the hearing, and then you shouldn't expect that there will be an 8-week hearing for your case. The hearing will be very short by comparison. So even in a complex case, it can be done in a day or two. And what German judges and by extension also culturally arbitrators do is they look at disputes from the perspective of what is relevant and what is contested. And with that, obviously other judges and lawyers do that as well, but it's very strong in the German mindset. And by doing that, they cut out all sorts of things and then say, well, we don't even need to take evidence on this because it's either not relevant or not contested or both. And that's how hearings can become very short and focus more on the law than on facts. So I think that's something to be aware of. Then the issue with the settlement that I mentioned earlier, that courts and in some instances also arbitrators try to assist in a settlement by giving positions. In the courts, you can't stop that from happening if the judge tries to do it. Really, in arbitration, the arbitrators will normally ask first whether they can or should do that. But that is also something where international parties are often taken aback by that kind of approach. And then maybe the last thing that's not so much of a procedural issue, but a substantive issue, which is under German law, there's a rather strong review of standard clauses or terms and conditions. So under German courts, at least, will look at a contract and they will identify a lot of things as general terms and conditions and then say, well, this is invalid because it favors one party too strongly than more strongly than the other. And they do that even in a business-to-business context, much less than in a business-to-consumer context, but they still do it. And that then can have a huge impact on the dispute, of course, if one clause is invalid for some reason. So if you choose German law, obviously it can be, if a party suggests a standard clause and you don't like it, it can be actually a good thing for you if you want to gamble on whether it might be invalid. But it's something definitely to be aware of.
That's quite surprising from a Swedish perspective that even in commercial contracts, a court can go into the clauses in that way.
Yeah.
And from a Danish, relation to a Danish company.
Yeah, I think I'll approach it slightly differently because I agree with most of what's been said. But I would say that for any business, it's useful to think about who are contracting parties, what kind of contracts do we have a strategy about which institutions are acceptable, which venues are acceptable, because obviously the seat is so incredibly important when you talk about assistance of the courts, and it shouldn't be sort of a last-minute negotiation to agree a forum that you've never considered, and to bring in lawyers every time to advise on this may not be feasible. So probably an overall dispute resolution strategy where you identify venues that you are happy with and that are sort of, again, in your toolbox in the course of negotiations, and similarly with institutions. In terms of Denmark as a venue, I think a dispute between the Swedish and the Danish party, I think most would be quite comfortable. There are obviously differences in our procedural approach, but given that both nations are sort of well acquainted with international arbitration practices, I don't think that there would be many surprises, and certainly, we feel very happy to have a Norwegian presiding over a dispute or similarly. So I don't think that the difficulty is with disputes between the Scandinavian countries. We know each other well. I think it's really more so when you go further away and your contracting parties are from other countries.
I agree. And that is also what we see. We work quite well together in the Nordic countries when it comes to disputes and in arbitral tribunals as well. That is actually the ending of this very interesting panel discussion. We are not opening up to questions from the stage, but we are going to stay here, and you are very welcome to come up here and ask us questions if there's anything you have on your mind at the moment. Thank you very much for coming. I hope to see you soon again.